Good afternoon. It's Tuesday, the 20th of April 2015, just after 1 o'clock. Sorry for the slightly delayed start. My mistake. Well, it's quite pleasant weather in Plymouth. It seems to be pretty pleasant around the country. And today I am joined by John Hurst. Are you there, John?
I'm indeed. Just unmute my microphone. Here we are.
Sorry.
Yeah.
Okay, brilliant. Now John is here to talk about, give us all an update on the situation with grand juries and what's happened since the February conference of the British Constitution Group. But before I discuss that with John, earlier on today I had a conversation with Kevin Edwards, because actually Kevin Edwards, as many people know, is an ex-councillor from South Wales. And he has taken up John's challenge to actually start running some grand juries, runaway grand juries, of course, and we can discuss what that means shortly. But I spoke to Kevin earlier on, and he introduced the issue of the grand jury that he held last week, but also he is giving us an update on the Linda Lewis case. And for those that don't remember, this is the case of the young girl that was taken at gunpoint, effectively kidnapped by Neath Port Talbot Social Services a number of years ago, and whose mother is still attempting to obtain justice for that, in the sense of dealing with the people who committed the what are effectively criminal acts. So anyway, this is a short video, takes about 15 minutes. This is what Kevin had to say about those issues, and then we'll be back with John. Okay, welcome to UK Column News, Kevin. It's good to see you again.
Hi, Mike. How are you doing? Nice to be back.
I understand you have been taking the initiative that was begun at the BCG conference, the British Constitution Group conference in February, and you've held your own runaway grand jury.
Yes, we did. 2 weeks ago, we held a grand jury in Port Talbot based on the Justice for Linda Lewis campaign. And Guy Taylor, grand jury sat. Mike, 22 people turned up, including Anne and her husband, who came over from Bristol. And in a nutshell, both grand juries agreed that the local authority, Neath Port Talbot Council, and individuals inside that council have cases to answer, as well as Judge Piers Higgins, who I believe is a magistrate up in Hereford, who has not acted lawfully with Guy Taylor. So yeah, it's all good news. Following on from that, we've had quite a few inquiries from different areas. We are Change in London are looking at setting up a grand jury, so the next couple of days we'll be hopefully be able to give them a hand.
Well, this is fantastic, and it'd be great if this gains some traction, because it is still a lawful process, as John will talk about in a moment. But at the end of the day, we've got to take this a bit further. So what's the next steps for you?
Well, the next step is John Hurst has got the paperwork, and John will be coming with us to submit the documentation into a magistrates court using Local Government Act 2000, Section 92, to take these people on under maladministration, which is the way that we need to do it. With the grand jury having rubber stamped the fact that there is a case to answer, we don't anticipate too much of a problem in being able to raise prosecutions ourselves, both against the local authority itself as a corporation, and social workers, chief executives, councillors, head of legal services as individuals as well. And hopefully we should be having that completed within the next 2 weeks.
Fantastic. Well, I'll get John to say more about that in a few minutes. But of course, we mainly know you from the Justice for Linda Lewis campaign, and I believe that there have been some developments in that case.
Yeah, there's been some very, very interesting developments over the last few days or so. We know it's coming up to a general election, and as you know, Mike, I gave up politics quite a long time ago, but I haven't met these two people. But Linda and some of the supporters have actually met a Welsh Assembly member called Bethan Jenkins, who I think if that's the picture there, she has recently done the London Marathon. I think she was sponsored to do so. I think it's depression is what she was covering. And her agent, who I believe is an absolutely outstanding fella, by the name of Duncan Higgett. Now, again, I haven't met Duncan. Duncan is the prospective parliamentary candidate for Aberavon in the general election coming up. And both of them have been fantastic as far as trying to get something sorted out. For politicians, I must add, they've been absolutely fantastic. Duncan has taken it off his own back, on Bethan's request. He has written off various letters to different authorities. One being to South Wales Police, who, if you remember from the last interview I did with you guys, Linda, myself and her father went up to the Met Police to report criminal activity over the kidnapping of a daughter. And of course the Met Police immediately transferred it back to South Wales Police, who were told in no certain circumstances that we wanted them involved. So we've got the Met Police perverting the course of justice by tipping off a police force that should have been under investigation by another one. Now, Duncan has written to South Wales Police and he's got a reply saying that they now are reconsidering whether to look deeper into the kidnapping of Linda's daughter. Duncan has also written off, I believe, to the Chief Constable of the Met to demand answers from him as to why he allowed one of his officers in Belgravia to pervert the course of justice and tip off South Wales Police that they were likely to be under investigation. So the signs are very, very good indeed. As I say, I've not met Bethan and I've not met Duncan, but Linda did give me full authority to say that where she lives in Aberavon, which is made up of Port Talbot and surrounding areas, the corruption that we know has gone on, the Linda Lewis case, the kidnapping was orchestrated by Neath Port Talbot Council in collusion with the Welsh Assembly government, that we believe now that we have a man by the name of Duncan Higgett who has done all the right things for all the right reasons. And on behalf of the Justice for Linda Lewis campaign, anybody who's watching in that constituency, we would urge you to vote for Duncan Higgett on Thursday, the 7th of March, 7th of May.
Now, I understand that both Duncan Higgett and Bethan have attempted to get some documentation from Neath Port Talbot Council. In fact, all the documentation, and it has been refused. Is that correct?
Well, it's not been refused. We've got the head of legal services in Neath Port Talbot Council, and he's a guy that I've mentioned many, many times before. I call him a common criminal by the name of David Michael. 4 to 6 weeks ago, Duncan Higgett asked so he could get the paperwork on behalf of Bethan Jenkins, everything that David Michael has in his possession regarding the kidnapping, or as they would say, the extradition of Linda's daughter in 1998. Now, Duncan's been waiting 4 to 6 weeks for David Michael to actually send documentation to Duncan. But as Linda's already explained to him, there's nothing new in this. Because when a former councillor, who was also a magistrate by the name of Keith Davis, was trying to help Linda many, many years ago, David Michael, over a 7.5-year period, categorically fobbed off Councillor Davis and would not give him any information regarding what had happened to Linda's daughter. Now, he has deliberately, in my opinion, he is perverting the course of justice. He has stopped a councillor, and he's now stopping an elected member of the Welsh Assembly government from doing their jobs properly. Now, we know the reason why he's doing this, Mike, it's a fact, it's the truth, that Neath Port Talbot Council absolutely have nothing to prove that anything that they did regarding bringing back Linda's daughter from the sick children's bed in Florida in 1998 is lawful or legal. It's quite clearly a case of absolute, total, 100% kidnapping.
And of course, there was a false passport involved in that.
Well, there was a false passport as well, but again, credit to Duncan Higgett and Bethan Jenkins on this. Just to double check the facts, Duncan actually wrote off to the Home Office and the Foreign Office once again, and both of them have come back and said that they have no record whatsoever of the child of Linda Lewis being extradited or having any application made for any extradition from America at that time. once again, that confirms completely that the Foreign Office were not involved, the Home Office were not involved. It was a case of Julie Resnicek and Alison Paisley, two social workers from Neath Talbot Council, having fraudulent paperwork that they'd made up with the full cooperation of Neath Talbot Council and the Welsh Assembly Government, heading off to Australia, flashing a couple of documents around, and then basically taking the child and bringing her back to the UK within 6 days.
I'm just looking at the notes that you sent me, and what was the circumstances around the gagging orders?
Well, again, this comes back to the head of legal services, David Michael. David Michael, when I first got involved in the Linda Lewis case, which must be about 8 years or so ago now, I run a website, Mike, and a colleague of mine also run the website, and we started putting up some of the evidence out, and to let people know what had happened. Now, we've since found out that the reason that Neath Talbot Council and the Welsh Assembly Government got a little bit frightened was that ITV Wales had actually sent a TV crew across to Florida to look at the evidence and interview people across there, and they were actually ready to go with a documentary series on the Linda Lewis daughter's kidnapping. Now, when Neath Talbot Council and the Welsh Assembly Government found this out, they immediately applied for a gagging order to stop myself and anybody else speaking about the case. Now, the point about this is the evidence that David Michael, head of legal services at Neath Talbot Council, put into court was fraudulent. He had no paperwork regarding the extradition, and he actually put the documentation in, this was in 2008, I believe, to say that this was a case of Munchausen syndrome by proxy, and that a gagging order, i.e. an injunction, should be put in place to stop people talking about Neath Talbot kidnapping Linda's daughter. Now, we now know, because we managed to get the paperwork off the courts, that in 1998, Judge Sumner KT, in a High Court hearing in Cardiff, totally ruled out the fact that this was a case of Munchausen syndrome by proxy. Now, that's in 1998. It was not a case of Munchausen syndrome by proxy. And yet in 2008, to cover up for his own council's criminal acts, David Johnson applied for an injunction based on Munchausen syndrome by proxy. So, I mean, I'm quite sure I've not seen the job description of the head of legal services of Neath Talbot Council. I'm sure it doesn't give him authority to override the findings of a High Court judge.
Indeed. Okay, so we'll just finally then, what are the next steps for this case? Obviously, hopefully, these individuals getting involved are going to bring some benefit, but where do you see it going?
Well, the next step is we're already planning to hold our next grand jury very, very soon. The last grand jury concentrated obviously on Guy's case and just one aspect, which is Neath Talbot Council and the social workers, the chief executive, the council, and the head of legal services in there. The next step will be we will be doing exactly the same regarding the Welsh Assembly Government, members of the Social Services Inspectorate, the First Minister Carwyn Jones, Welsh Assembly Minister, Welsh Assembly Representative for Aberafon David Rees, and many, many others who have continued this lie and this corruption going. But I'll just finish off on one very, very quick thing here, Mike. A friend of Linda's, who's one of the people that's got the discs with all the information on, phoned me literally 10 minutes before you came on air. And I don't have the full details, but she's come across a letter, and I believe it was from around about 2000, from the former Attorney General of the United Kingdom. In a response to Linda, he's written back, and I've just scribbled the words down very, very quickly. I don't know which department took your daughter. Now, that's the Attorney General in the year 2000 who has absolutely no idea which department, Foreign Office, Home Office, etc., took Linda's daughter. Now, how can everybody not see that? The only person that is still holding out, Mike, unfortunately, and it's an absolute disgrace to the Welsh Assembly Government and the people of Wales, the only person that's ever written back to Linda and says that he is satisfied that everything has been done correctly and above board is Carwyn Jones, who is the Welsh Assembly member for Bridgend and the First Minister of the Welsh Assembly government. Absolutely unbelievable. I don't know which department took your daughter. And that comes from the former Attorney General of the United Kingdom in the year 2000. So lots of stuff to go on with, lots of things to do. We're grateful for the help that Duncan Higgett and Bethan Jenkins have put together. And before I finish up, I'll just need to say that I think you'll remember a couple of years back, there were 63 councillors in Neath Talbot Council. 62 of them, in my opinion, are endemically corrupt, who have ignored all the evidence over the Linda Lewis campaign. All apart from one chap, an independent councillor for Seven Sisters called Steve Hunt. Steve has consistently backed the campaign. He has recognised that his council has committed serious crimes against an innocent mother and young child. And, we thank Steve Hunt for that. And finally, if I'll finish on this, Mike, as I say, I don't do politics anymore. I'm purely being asked to endorse two people who are doing the right things, not the political party. And I certainly wish Duncan Higgett all the success and Bethan Jenkins, and I hope they keep this work going. But I would like to put it to Duncan and Bethan that I suggest that they call immediately a meeting of their Plaid Cymru councillors in Aberavon, and get together with the independents, which includes Councillor Steve Hunt, who's been excellent, and have a chat together, because no councillor is going to be exempt from legal action now. Not one of them. We're not even going to bother with the criminal Labour Party councillors. My suggestion to Duncan Higgett and to Bethan Jenkins is to get together with your councillors, invite Steve Hunt and his little group of independents in, and let's get this sorted out, because David Michael and a lot of people in Neath Talbot Council have absolutely no right to represent the people of Neath Talbot. And the other point, one more point as well, I'm grateful to Bethan Jenkins, and the sooner that this happens, that I believe that Bethan Jenkins has said that the Linda Lewis case will be raised by her very soon in the Welsh Assembly government where it needs to.
Brilliant. Okay, so just finally then, this is your website. How do people get to that, Kevin?
Quite simply, Mike, the website address is www.cllrkevinedwards.blogspot.co.uk, and if anybody wants to drop me an email, my email address is on that. Okay, brilliant. Thank you very much for joining us, Kevin, and we'll speak again soon, no doubt. Okay, thanks again, Mike. Okay, so we're back, right, just before I bring John Hurst on to discuss this a bit more, just a reminder of the events coming up. So 1st of May, get to the Ye Olde Trip to Jerusalem Inn in Nottingham, not too far from the train station. Do come along to that. Starts 9 a.m. on this Friday. Don't forget the showing on the 2nd of May, also in Nottingham, of the I believe this is the final pre-release showing of the Great British Mortgage Swindle, and so do come along to both those events if you can. Now, John, Kevin there talking about running his own grand jury in South Wales just a week or so ago. How did that come about? Because obviously it was inspired by what happened at the BCG conference in February, but this was a second bite at that same type of operation.
Well, that was the objective, wasn't it? To spread the word. We've done the research, and we know we're right, because it's in the textbooks. That's one of the definitions of what's lawful. If it's not in our textbooks, it's not our law. Things created out of thin air are void. So fair play to him. Kevin and Linda have been battling for 17 years, and they've exhausted all the conventional methods. They did manage to extract from their local authority via an honest councillor an admission that the council had acted unlawfully at the beginning of the whole thing. And as people who've read Shirley Liebald's article on void court orders will know, nothing can be built on nothing. So if the first seizure was unlawful, in law it was a kidnapping, because kidnapping isn't just taking somebody by force. Kidnapping is taking them by fraud as well. It was a kidnapping, and then everything that's happened after that is therefore void. And one of the consequences of an event being void, shall we say, is that time doesn't run, so there's no statute of limitations. So no matter how old it is, it's still void. And and it will result in a civil claim as well. So we've got the criminal grand jury process, and at the same time we've got a civil claim under, for those who'd like to look it up, Section 92 of the Local Government Act 2000, which says where there's been maladministration, which there has, the council may make a payment or some other restitution. And it's, in this context, may means must, because there are a number of judgment and statutory authorities to the effect that when the injustice has happened, and therefore the applicant is entitled to payment. So may, in this context, means must.
Right. Well, just for those that aren't aware, obviously we ran 4 grand juries at the BCG conference in February, but many people may believe that the grand jury is something which no longer applies in this country because it had not been run for 80 years or something prior to that. And actually what we have been doing is running what are called runaway grand juries. So what is the sort of, just give us a brief law lesson here in how this is possible.
Okay, well, it goes back to the traditional way of the king keeping an eye on what was going on. So if you go back to 1192, for example, the king would appoint good and true men to be inquisitors, and they were expected to investigate what had gone on in their locality and report it to the king. And a similar thing applies today. Any one of us might be summoned to be on a jury, mightn't we? And when we get to the court and we're allocated on the jury, we're there by right. We don't have to be appointed a juror. We are summoned to be a juror. You see the concept?
Yeah.
So it's a question of, do you have to be summoned? Well, the answer is no, because everyone's got a common law obligation to maintain the peace, which means informing the authorities in the event of you discovering information about a crime. Up until 1967, there was a common law offence of misprision of treason. That's still there, but added on top of it is a statutory measure, Criminal Law Act 1967, Section 3 and 4, which talk about concealing an offence and concealing an offender. So really, the two legal bases of a grand jury are the power of 12 to judge one, which is what a jury is about, and the fact that when you do find information about a crime, you're required to tell the Crown about it.
But the DPP and the Crown Prosecution Service would argue that this is no longer a valid mechanism for deciding whether a crime has been committed.
Well, they will rely on an Act of Parliament from 1933, the Miscellaneous Provisions Act 1933, which said instead of an indictment being a document which is signed by the foreman of a grand jury having heard the evidence, they say a court official can sign an indictment. If they're claiming that the grand jury process by indictment is invalid, it was replaced by the 1933 provision. They don't take into account the fact that a grand jury can also issue a presentment. Got 2 powers. An indictment is something where you have a victim that comes along to the grand jury in the courthouse. Let's imagine you're a juror at the Old Bailey, sort of 100 years ago. You'd be summoned by the sheriff and you'd arrive, and then you'd be allocated either to a grand jury or a petit jury of 12. And the grand jury decides whether there's a case to answer, and the petit jury deals with a trial where the rules of evidence apply and the rules of fairness apply. A man may know his accuser, trial's got to be in public, and so on. No hearsay evidence. And it was just random which one you went to. Now, what we've done is we've researched the Act of Parliament from 1993, and it doesn't mention presentment. It doesn't mention the concept of presentment at all. And common law, a measure is not repealed unless it's actually spoken about. So, because the 1933 Act doesn't mention presentments, it can't be held to have repealed them. And in actual fact, there's an Act of Parliament from 1351 still in force, which says that juries may indict or present. So we're going down the present route. Now, the significance of the presentment is, in actual fact, that once a jury have presented a case, the Crown is required to put it on trial. So the powers of the CPS to take over cases and stop them can't be held to deal with presentments, because they don't mention presentments.
So actually, if the CPS was to refuse to proceed with this, it would, or if they attempted to block this, it would actually be unlawful. Is that fair?
Well, yes, because the concept is that the current regime think they've got hold of the method of manufacturing legislation, Acts of Parliament, and they think that we pass an Act of Parliament and it blocks everything else. But in reality, as a consequence of the coronation oath, that's not so. Now, the coronation oath says the Archbishop asks the Queen, "Will you rule the kingdom according to its laws, customs, and statutes agreed on?" So statutes agreed on is a reference to giving royal assent to an Act of Parliament. So in order to comply with the oath to rule according to laws and customs, the Crown can't give royal assent to a document which repeals laws and customs. So Acts of Parliament can't repeal laws and customs because the Queen said she wouldn't, and it really is as simple as that. So when you're interpreting an Act of Parliament, you look at the common law as it was before. You look at what the Act of Parliament says, and penal statutes are to be strictly interpreted. If it doesn't actually mention repealing a common law right of the subject, even mainstream courts will say it hasn't. Because we go a stage further than the mainstream courts. We say any measure which purports to repeal a common law right isn't an Act of Parliament, and it can't be an Act of Parliament because the Queen promised she wouldn't do that sort of behaviour. Now the courts for about 100 years haven't actually tested the validity of an Act of Parliament, but there's a logical inconsistency there, because if a court tests the validity of an Act of Parliament and finds it isn't an Act of Parliament, they're not going against an Act of Parliament because it isn't one. So the issue is it's called Marbury versus Madison, an American case from 1803, which decided that if something was if an act of Congress was contrary to the Constitution, then it wasn't an act of Congress because Congress didn't have power to do it.
Right.
And now I've discovered recently that Supreme Court judgments should be binding in all the common law countries. So I would say Marbury versus Madison applies in the UK. Now, I'm researching that, and then that seems quite a useful tool. But that would be one of the arguments if ever a CPS official says, "No, we can forget a grand jury, and we don't have to do what they say."
So actually, bearing all that in mind, the grand jury is a hugely powerful tool for for everybody, actually, because if the CPS refuses to prosecute for any reason, if I say the words Lord Janner at the moment, and perhaps that might be quite appropriate, the CPS refuses to proceed on any basis, we can actually take over that job and force them to do it.
That's my understanding. In order to take it over, of course, we'd have to prosecute the prosecutor as well. So let's say a Crown prosecutor is corrupt. Well, let's say the Director of Public Prosecution is corrupt. As time goes by, it appears that she was a pupil in the chambers where Janet was, and she took advice from somebody who stood in those chambers and that sort of thing. It's got a smell about it like that, which is the case, hasn't it? That will be one for a grand jury, I would say. And then, of course, it'd be a marker for the establishment. The establishment would fight it's quite hard to resist it because, as you say, it takes away their power. They've got a monopoly on who can be prosecuted and who's not prosecuted. And that's not what the common law intended.
Okay, so obviously there were four grand juries held at the BCG conference. 3 of them returned a verdict, if you like, and then there've been 2 held in South Wales last week, and they've both returned. So there's 6 cases on the books at the moment. What is going to happen with those next, and what actually is the progress of the 3 that returned in Telford?
The progress is that the powers that be, the Lord Chief Justice, the Home Secretary, and the Lord Chancellor all know what happened at Telford because I've sent them copies of the articles, and I've engaged in a conversation with the Attorney General's minions about the topic. So the establishment knows about it, and I've lodged them in the list office at the Old Bailey as well. So they're in the system now. They haven't been rejected, which I think is quite significant.
How long would it take, or how long would you expect it to take for a rejection to arrive?
Well, it's having been a bureaucrat myself, you're talking months rather than weeks because it's got to be cascaded up the food chain. Somebody's got to take it on, realise it's above my pay grade is the phrase that's used, isn't it? It's above my pay grade and pass it upwards. And even passing something upwards in the hierarchy is a problem because you get accused of being the problem rather than the problem.
Yes.
So it requires a certain amount of bottle, and the fact that they haven't issued a peremptory no, I think is quite significant. You recall we were holding the Lord Chief Justice and the Lord Chancellor to account in the article I wrote called "Grand Juries at Telford, What Next?" In the context of the 800th anniversary of Magna Carta, they made sort of glowing speeches saying we'll uphold Magna Carta. Well, we're going to hold the buggers to it this time.
Right.
Which is the last thing they want. Strictly speaking, it's 5 case actually, because the Guy's case was held a second time at Port Talbot, and there's nothing wrong with that because there is a rule against protecting against double jeopardy that only applies to a petit jury trial. You can have more than one go at a grand jury. So Guy's was upheld, and then Linda was added to it. And in actual fact, there's going to be a grand jury, I understand, in Nottingham on Thursday. It's the run-up to the Nottingham event. I'm not privy to any of the arrangements because it's a need-to-know basis, and people were briefed on the day, similar to the rest of Judge Peake. But I understand that Guy's found a venue, and we're going to invite the locals to have a grand jury about local topics. And they could well be added to the list, and they will go to the local court. Guy's one's got to go to a court outside Herefordshire because it involves a Herefordshire judge, a Herefordshire County Court judge. So the plan is to take that to Port Talbot late next week. And we've got a good working relationship with the senior clerk at Hereford, Hereford Magistrates Court, and he's allocating time for us to do the other 4. So a couple of weeks' time it should be done now.
And ultimately, this would result in private prosecutions. Is that right? Unless the CPS takes over the cases.
Yeah, that's right. Well, one of the things I'm going to go. I mentioned I'm exploring different strategies now. In my presentation at the conference, I talked about relator actions, didn't I? Now, a relator action is where the Attorney General is invited to assist a private person secure a public right. I visited my friend and inspiration, Bob Lomas, a couple of days ago. So he's the founder of the Magna Carta Society, and I ran relator actions to him. And his understanding of relator action is that it was invented at the time of enclosures. Now, the land enclosures. It was a common law. If you were a villager, you had a slot on the open field system, and you could also put your pigs into the forest and take firewood and that sort of thing. And that was the position up until enclosures. Then Parliament passed acts which infringed the common law, and there was a big hoo-ha about it. And a lot of people tried to claim their common law rights, and the Attorney General at that period suddenly decided that he had a monopoly on public right cases. So people who were claiming to claim their public right to the Commons found that they were blocked. So the relator action is a very dubious legality, in my opinion. Right. I've done some research about it. As it happens, another founder member of the Magna Carta Society has come to the front. He's late Army Major John Gurrier. It's 1974, and South Africa is a political hot potato. The Post Office Union in the UK refused to send post to South Africa. And John Gurrier, although he didn't particularly want to post anything in South Africa, objected on the basis that the rule of law means that you can't do that sort of thing. So if you look at a case called Gurrier against the Attorney General and the Post Office Union, you'll find that the history of the relator actions is discussed. And what we find is a lot of the authorities and that the Attorney General is relying on are very, very old. Now, normally I say if it's old, it's good, don't I? I say more generations of our ancestors have accepted it. In this case, they're not proper authorities; they're just custom and practice built up. One, for example, is that if you write to the Attorney General and say, "I'd like you to assist me with the relator action," he will say, "Well, have you run it past a barrister, which costs £3,000 to get a barrister's opinion?" The authority for that, according to the Gurrier judgment, is custom and practice around 1610. So the Attorney General in 1610 says, "Well, I've always had this practice of asking a gentleman of the bar to give an opinion." Now. The significance of that is it's pre-1688. It's pre the modern form of the coronation oath, and it's not an authority. It's just a practice that built up. So we got substantial grounds for challenging the Attorney General on that concept. And from what we know from Bob Lomas, I discovered from Bob Lomas the other day. I'm going to research the concept of can the Attorney General block an action to claim a public right anyway. So we live in interesting times, and all these things are coming out. So at least one of my cases is going to go via the Attorney General to try and clarify that, and the other will just go down the conventional route. Yes, they are in the nature of private prosecutions, but some of them, they're all serious, and there is a case for the CPS taking them over and assisting rather than blocking. So I'll be asking for that as well. The significance of laying the information is this: once the information is laid, then the disclosure process and the fact that the defence have to give their argument to justify their actions mean that I get access to internal documents from the bodies that these people work for.
Yes.
And that must be quite a scary thing from the other side, because you can bet there's lots of skeletons in the cupboard there they don't want revealed.
Yeah. Okay. So I mean, this is brilliant stuff, John. So it is making progress. There are more groups around the country wanting to run their own grand juries.
Yes.
So just in a minute, because we're pretty much out of time. I mean, what do you hope is going to happen next? Are we going to see a flurry of these and actually a lot of? I mean, just so that everybody knows, these private prosecutions are with regard to misconduct in public office, and it fits in very well with the argument that we've been making pretty much since Birkenhead, where we were demanding that people do their jobs. And that's really all we're asking, isn't it? And so these people haven't done their jobs. They've broken the law. They're being prosecuted for misconduct in public office. And we hope that many more people are going to take up the mantle, as it were.
I agree. Although a few test cases will be sufficient, because the legal system is set up to respond to test cases. Let's say that something goes before the courts that determines that there should be a change in practice. The Attorney General issues what's called a practice direction, and everybody reads it, and hopefully everybody takes it on board. So, yes, there were more cases coming forward, but we only need to be successful once. It's like the IRA said to Mrs. Thatcher. Apparently, she survived the Brighton bombing, and they said, "Well, you were lucky once." Yeah. Yeah. So that's the context we're looking at.
Okay, well, brilliant. Thank you very much, John. It's great to have you on, and hopefully we'll hear more from you in the not too distant future.
Yes, indeed. Yes, for those that are going to Nottingham on the day, as I say, I don't know what's going to happen. I'm in communication with somebody who's got a letter from an inspector in the Nottinghamshire Police that says, we understand Chapter 61. We're not going to obstruct anybody. We're not going to arrest anybody for it. We will stand by to prevent a breach of the peace. So that's good. Now we've got to clarify that. I'm also in communication with I'm trying to get in communication with the Chief Constable to make sure he knows that, because there could be a confrontation with people who know what the law is and constables that don't. Yeah. Of course, that's what happened at Birkenhead, isn't it?
Yes.
So we're seeking to avoid that in advance by making sure the other side know. The bottom line is, if it's in the law book, it's law. If it's an opinion not supported by a law book, it's not. So we're on the winning side.
Brilliant. Okay. Thanks again, John. Speak soon.
Right. Bye.
Okay. So moving on then. Really only one story I want to cover here, and that is this one. Ex-Rotherham children's boss Sonia Sharp quits Australia role. Now, just to really what I want to do here is to give the background to this story, because the BBC has, as you might expect, utterly failed to do that. So what the BBC said was that she led Rotherham's Children's Department from 2005 to 2008 before running education services in Victoria in Australia. They say that at least 1,400 children were sexually exploited in the time between 1997, this is Rotherham, and 2013. Apparently the Minister of State, Gavin Jennings, in Victoria has said that Dr. Sharp is seeking opportunities outside of government. So what has this all been about? Well, basically, it's all come about as the result of Martin Bryden, who actually hasn't been on this programme since 2012. He has been working diligently since then, since before and since. And really, Martin's main target is common purpose. And he's been working with us on the issue of common purpose for a long time. On the 5th of November 2008, Martin Bryden pointed out to Sheffield City Council, because actually this lady has a long history of working in councils, and she always worked in education. This is Sonia Sharp we're talking about. She always worked in with local authority in their education department. And he pointed out to Sheffield Council, which was her last role, which the BBC didn't mention, before she went to Victoria, that there was no evidence of common purpose having done CRB. Oh, well, before we even get onto that, I should get to this one, because Martin Bryden had remembered that Sonia Sharp had been convicted of a racist offence under the Section 2 of the Race Relations Act in 1976. So he raised this with Sheffield Council while she was there and got rebuffed. Following that then, Well, let's just look at her history. She started at Birmingham City Council, and that's where she ended up having this racist conviction from. After Birmingham City Council, she went off to Leeds City Council. Following Leeds City Council, she ended up at Rotherham Borough Council, and following Rotherham, she ended up at Sheffield City Council. But each one of these jobs seemed to be linked to her connections to Common Purpose. And this is all Martin's research, really, that has exposed this. Now, as I say, in 2008, he pointed out to Sheffield Council, where she ended up, that there was no evidence that Common Purpose was providing CRB checks for Common Purpose staff that were working with children. And Lord Paul Scriven, he's now a Lord, he is the former leader of Sheffield City Council. He was the leader of Sheffield City Council at the time this was made. And on camera, when Martin Brighton brought this issue up of CRB checks, we'll come on to that in a second, he launched a charade of abuse against Martin, falsely accusing him of making allegations of abuse. And then the Sheffield Star, which is a corporate sponsor of Common Purpose, we should point out, published the lies that Mr. Scriven, Lord Scriven, gave on the day. So what was this about? Basically, Common Purpose runs a course for children called What Is Your Turn? And this is typical of Common Purpose courses. They say it's a leadership course for young people. They say Your Turn challenges young people to think in new ways about the place where they live and the world around them, to examine to examine how decisions are made and see how they can make change happen. So that's what was going on. But unfortunately, Common Purpose was running these courses at weekends, inviting children along, and apparently there's no evidence whatsoever that any of the Common Purpose staff running these courses had CRB checks and were actually therefore qualified to work with children at all. Now, Martin Brighton originally raised this at Sheffield Council in 2008. By 2010, over 18 months later, he still hadn't received any evidence of this, and to date, as far as we know, there is no evidence that CRB checks have ever been carried out for Common Purpose staff running these courses at Sheffield. Now, why would we be concerned about this? Well, Common Purpose, of course, has its own problem with paedophilia. And here's Matthew Byrne, for example, who was a Common Purpose Advisory Board member. So in other words, what he was doing was selecting other Common Purpose members. So if you have a secret organisation that operates by Chatham House rules, and on your selection board, effectively, you have a paedophile, and we know that paedophiles operate in rings, then perhaps, I'm not saying this is the case, but perhaps Matthew Byrne selected other paedophiles to take part in Common Purpose courses and become Common Purpose graduates. Now, let's just remember, because the headline here is a little misleading, but in fact, Matthew Byrne admitted making nearly 9,000 child porn images. But in his court case, he denied a string of other offences. So he faced a total of 32 charges, including rape, assault by penetration, and false imprisonment. And he was accused of sex attacks on 7 different women, and in some cases is alleged to have beaten women with a. So he was eventually found guilty of sadistic torture of a series of prostitutes. We can't move on, of course, without reminding everybody about this photograph. Now, I could say that in David Cameron's defence here, he doesn't look like he's having the best time. His body language suggesting that he's not hugely excited to be standing beside Matthew Byrne. But here's Michael Heseltine and David Cameron giving Matthew Byrne an award. But Matthew Byrne's not the only problem Common Purpose have had, because of course James Rennie, and this article here pointing out that he was one of the ringleaders of Scotland's biggest paedophile network. So this is not a small thing. Jimmy Rennie, also Common Purpose. We shouldn't forget Frank Sheenan, who was Chief Fire Officer of the West Midlands Fire Service. He resigned from his post because he had been arrested on suspicion of making indecent images of children. And then, of course, Sir Peter Fahey, and also 2 detectives, they were given gross misconduct notices by the IPCC, and the claims against Fahy relate to his alleged support to what was called a poorly handled investigation into a suspected sex offender. So although Sir Peter Fahy himself is not being called a paedophile here, there still looks like there was some kind of cover-up going on in that situation. So Peter Fahy also, well, he actually actively promotes Common Purpose. He appeared in a Common Purpose promotional video called "What Makes for a Successful Collaboration." He's also, by the way, a member of UN CivPol, which is the United Nations Civilian Police. But anyway, getting back to Sonia Sharp, everywhere she went, she was arranging funding for Common Purpose. So each of these councils that she was working for, she was busy organising contracts for Common Purpose. That's called insider dealing. And here's an example. For example, Rotherham Council spent £30,000 on training for staff. That's in the Daily Star. So anyway, she eventually ended up going to Victoria in Australia, and Martin Brighton continued the pressure because he then told the local press in Victoria what was going on. It was interesting that just 3 weeks before Sonia Sharp moved to Victoria, by the way, Common Purpose also opened an office in Victoria, so perhaps they were expecting similar lucrative contracts to be handed over from her new job. And the other point to make here is that Sonia Sharp, as I said, always working in the education sector within the local authorities. In every single case, in every one of those local authorities, and in Victoria, where Sonia Sharp was working, education suffered and children suffered as a result. So eventually, Martin Brighton had contacted the local press in Victoria. Eventually, the national press in Australia got wind of the story, and they've been putting pressure on ever since. And that has finally resulted 8 years after Martin started trying to expose the corruption of this lady, that she has managed to be thrown out of her job. Now, obviously, there's the chance that she's going to end up back in the UK. Well, in that case, we've got some questions to ask. What is she going to end up working at? And the strong suggestion from us and from Martin is that she should never again be working with children in any way, shape or form. So there's quite a lot behind the story of Sonia Sharp's apparent sacking in Australia. And of course, we must not forget that it's not just her, because this is happening right across the country, and anywhere where there is this kind of activity going on, Common Purpose is to be found. Now, if you want to get a better feeling for this, do have a look at the Rotherham Common Purpose Effect article written by Martin Edwards on the UK Column website. Please distribute this far and wide, because as many people as possible need to understand that although individuals are doing these things, individuals like Sonia Sharp, there are quite a number of individuals in positions of authority, power, whatever you want to call it at the moment, within local authorities. And pretty much everywhere you look, you find Common Purpose. So we need to do something about this organisation, and we need to do something about the activities of their graduates. And on that note, I'm going to say goodbye and see you tomorrow at the same time. I'm hoping Mark Anderson will be with us tomorrow from American Free Press again to talk about various US things, including TPP, the Trans-Pacific Partnership, of course. So hope you've enjoyed today's programme, and we'll see you tomorrow. Thanks.